The Commerce Clause is found in Article 1, Section 8 of the Constitution, among the list of the enumerated powers granted to Congress. The clause states, in part, that Congress shall have the power to regulate commerce among the several states. This may seem like a straightforward command, but its meaning and scope has been debated in the courts throughout history. In an early Commerce Clause case, Gibbons v. Ogden, Chief Justice John Marshall noted that, while the clause explicitly gives Congress the power to regulate only interstate commerce, Congress may regulate at least some activity that occurs within a state. He wrote, "The power of Congress does not stop at the jurisdictional lines of the several states." Later, the court underwent a period of limiting the scope of the commerce power indirectly by using a more narrow definition of what constitutes commerce. Their narrow definition became most noteworthy when President Franklin Delano Roosevelt took office, and Congress began to pass a great number of regulatory laws as part of FDR's New Deal program. The court responded by striking down many of the laws in a series of close decisions. From mining regulation to child labor laws, the court held that the Congress had exceeded its commerce power, and the laws in question dealt with manufacturing, which was not commerce and should be under state control. But in the 1936 to 1937 term, Justice Owen J. Roberts had a change of heart regarding the Commerce Clause. With Roberts suddenly voting with the justices that supported a broader definition of commerce, this change, called the switch in time that saved nine, meant that the court began to uphold the New Deal laws instead of reject them. For several decades, the court continued to sanction this expansive interpretation of the Commerce Clause, which allowed for Congress to use the commerce power to justify their passage of the Civil Rights Act of 1964. This law even withstood challenges from critics who argued that it was too much of a stretch to justify the law as regulation of interstate commerce, when the aim of the legislation was to ensure civil rights. It seemed that the scope of the commerce power was almost limitless. However, starting in 1995, the Rehnquist Court heard a series of cases that drew attention to the limits of the commerce power. In U.S. v. Lopez and U.S. v. Morrison, the court struck down the Gun-Free School Zones Act and the Violence Against Women Act, respectively, holding that the laws at issue were too far removed from the regulation of commerce to fall within the scope of the Commerce Clause. In Lopez, Chief Justice Rehnquist defined commerce more explicitly by listing three categories that Congress has the power to regulate, including the channels of interstate commerce, the instrumentalities, or the things that move within interstate commerce, and lastly, activities that substantially affect commerce between the states. In thinking about the last category, a 1942 case called Wickard v. Filburn becomes relevant. In Wickard, a farmer challenged an agricultural law that limited the amount of wheat he could grow. He argued that the small amount of wheat he produced in excess of the law's limits was used for personal consumption, so it didn't have a substantial effect on interstate commerce. But the court found in a situation like this, Congress must consider what would happen if all similarly situated farmers followed Filburn's lead. This, they pointed out, would affect interstate commerce. The principle of adding together similar economic activity to determine whether it would have a substantial effect on interstate commerce is called Wickard aggregation. For more information on other constitutional issues or Supreme Court decisions, visit harlaninstitute.org or fantasyscotus.org.